Hello everyone, so today's A-level law OCR. Um, yeah, so for this we'll cover criminal law in this video, then I'll do tort law in another video, contract another. What I'm going to do is though, I'll go through the main offences in this video, then the evaluations for each area of law I'll do in a separate video, because, well, to be fair, I haven't collocated all my notes yet, so I'll have to do that. And yeah, so it'll be criminal, obviously, non-fatal offences, fatal offences, and partial defences, property offences, and preliminary offences as well. So attempts will be there too. So non-fatal offences to start with is assault. So it's a common law offence with a max sentence of 6 months imprisonment or a level 5 fine, which is told in the. So it's a max sentence of 6 months imprisonment or a level 5 fine, which is defined in section 39 of the Criminal Justice Act 1988. Please remember that assault is not defined in this section and act. It's just the sentencing, the maximum sentencing is defined. So RV Island defines assault as any act which intentionally or recklessly causes the victim to apprehend immediate and unlawful violence. So when you're writing your essay, you obviously separate it into its elements. So for the actus reus, you focus on the act itself first. So the case of Constanza deals with words alone. Ireland deals with silence. So also assault, the actus reus for assault can be satisfied through a physical act or words, but it cannot be through an omission. So fast forward, Tuberville versus Savage. Words can negate the initial threat. Light actions can negate words and reinstate the threat. So the actus reus, the act must cause the victim to apprehend immediate and unlawful violence. So Lamb defined apprehend as anticipation. So it essentially just said that to apprehend can be interpreted as to anticipate. This means that the victim does not need to fear violence, just believe it is going to happen. So the immediacy of the threat is the next element. It's relatively straightforward if the defendant and the victim are in close proximity. Smith v. Chief Superintendent of Woking Police Station. This case essentially said that the police officer did not know what could happen next, but whatever it was of violent nature. So you don't have to know specifically what is going to happen, like they're going to throw a punch, they're going to push you, but you just have to know it's going to be of violent nature. So Burstow said that the victim only needs to perceive the possibility of an attack, and this does not need to be rational. Rulings show that immediacy can be interpreted more generously as imminent. So to say immediately and to use the concept of immediacy almost suggests that it's going to happen within like 0.1 seconds of the threat being established. Realistically, no, but imminency is. But obviously the longer the time frame, then obviously the weaker the prosecution will be. So the final element of the actus reus, the victim must apprehend unlawful violence. If the force threatened is unlawful, it will not suffice for the actus reus of assault. Usually force that the victim has not consented to is unlawful and then necessarily violent. So the mens rea for assault is defined in RV Savage, which is to intentionally or recklessly cause a victim to. So therefore you use the test for direct intention in Moen. So you ask the question, was it the purpose of these acts to cause V, so the victim, or replace it with the name of the person in the scenario, to apprehend immediate and unlawful violence. If you cannot prove it through direct intention, then move on to the Cunningham test in recklessness. So you ask the question, did D foresee the risk that his acts would cause the victim to apprehend immediate and unlawful violence, and did he take that risk anyway? So there must be, remember, in your recklessness, there must be an appreciation for the risk. So battery is any act that intentionally or recklessly causes the unlawful application of physical force directly or indirectly upon another person causing offensive contact or bodily injury. So you should be careful by bodily injury. So something like reddening of the skin, that could class as battery. But something like a fractured finger, or like a really bad bruise, that's more likely to be something like ABH. So you have to, when speaking about bodily injury, personally I wouldn't use it in the definition, but this is the definition this is the official definition. So this is defined in Ireland v Ireland Burstow. So yeah, I personally, when describing it in the exam, I would say causing offensive contact, and then cut it off there, just so the examiner doesn't like try and do you dirty. So Section 39 of the Criminal Justice Act defines the sentencing powers as the same as the last one. So the actus reus for battery starts with Collins v Wilcock. So any touching of any kind, however slight, can amount to a battery. So R.V. Thomas says this is clothes included. So if you're pulling on somebody's shirt, or if you're repeatedly touching somebody's clothing, even though it's not direct contact with their skin, it's still classes as assault. It's still a attachment of themselves. So Fagan v Metropolitan BC. So battery, when accidentally applied force, is not removed. In this case, the defendant was driving his car and he ran over a police officer's foot. So when he was told to remove it, this was accidental, and when he was told to remove the car, he refused, and this caused a battery, because although the force was accidentally applied, he didn't remove it. So contact can include reddening of the skin or minor grazes and scratches. The force can be a touch to a punch. So minor grazes and scratches and reddening of the skin is important, because if you look at the definition of wounding in JCC v Eisenhower, so minor grazes and scratches do not constitute a wounding, which means that they are allowed to constitute as a battery. Same with reddening of the skin with ABH and GBH. It's not enough of a severe injury to constitute either of those offences. So indirect battery is the next one. So direct and indirectly in your definition. R.V. Martin, you have the case of that. DPPVK is for object. For R.V. Martin, after this recording, I'll look it up and I'll attach the case facts to it. So DPPVK is where force was used via an object. Haystead was where force was applied indirectly through another person, and Santana Bermudez is where there was an omission, where there is a duty to act. So if you compare the two, obviously there's the aspect of actual physical force being applied, but also in assault you cannot have an omission, but for battery you can have an omission. So the next element of the actus reus requires that the application of physical force must be hostile and unlawful. So the case of Brown and others states that if force is unlawful, then it is necessarily hostile. So the mens rea. R.V. Venner tells us that battery is intentionally or recklessly applying physical force to another. So this means that it is a basic intent crime, so you should use the Mohan or Cunningham test for direct intention or recklessness respectively. So direct intention with Mohan, was it the purpose of D's act to apply unlawful physical force to another? For recklessness, did D foresee the risk of applying unlawful physical force to another, and did he take that risk anyway? Please make sure to if the case scenario calls for it, acknowledge the concepts of transferred malice in Latimer and Mitchell. So next off, also for the mens rea, where it's a basic intent crime, so for ABH, I'm not going to list out the tests for them because they should be already memorized anyway, and it will take time to read them over and over again. So ABH this time. So section 47 of the Offences Against the Person Act 1861 tells us that ABH refers to assault occasioning bodily harm with a maximum sentence of 5 years imprisonment. So comparing this to common assault, so common assault refers to assault and battery, this is governed by statute. So to prove ABH, first you need to discuss the full offence of assault or battery. This is because you have an underlying offence. So you have an underlying act when there is an ABH. So first there is an assault, or first there is a battery that results in actual bodily harm, or that occasions bodily harm. Next, you should establish causation if there is no direct physical contact. So firstly, use factual causation and establish that through R.V. White, asking the but-for test, which essentially asks, but for the actions of the defendant, would V have suffered the assault, or would V had suffered injury anyway, or if it's GBH, serious injury. You should rephrase it as you go along, but it should follow that framework of phrasing. So RV pageant, unsuccessful. You don't need to mention RV pageant in your essay unless if the scenario specifically has, if you cannot prove factual causation, for extra brownie points, you might want to put it in, but you don't necessarily have to. You just ask the but for test, name RV White, but memorizing RV pageant won't do any harm. So for RV Kimsey, for legal causation, this is essentially asking whether they are legally responsible for the outcome. So for this, you need to ask whether there is a more than trifling link between the act of D and the outcome that V has suffered from. So through this though, there's a concept called novus actus interveniens. So these are basically just intervening acts. It's just fancy Latin. So RV Jordan is for medical negligence, which was proven as a successful case. RV Cheshire, however, was unsuccessful. RV Hart is a New Zealand case, so it tackles unforeseeable natural events. So these are things like tsunamis, earthquakes, tornadoes. Williams and Davis is the victim's own act, so that was unsuccessful. RV Roberts, victim own act, which was successful. In RV Roberts, she jumped out of a car to escape danger. So although she acted quote unquote foolishly, it was the lesser of two evils between her suffering greater danger or being susceptible to greater danger. So next, you must prove that the harm was caused, and then you must differentiate it between physical harm and psychological harm. So physical harm in Miller, so harm can be any hurt or injury calculated to interfere with the health or comfort of the victim, but it should be more than transient or trifling. So that's similar to the principle in R.V. Kimsey. So psychological harm is tackled in Chan Fook. So mere emotions such as panic, fear and distress do not suffice. The harm needs to amount to a clinical condition. So if you have ABH and you try to argue that there is psychological harm done, you need to prove that this has resulted in a disorder such as depression or PTSD. You could argue ABH there. But to say that somebody panicked a lot or they had like a anxiety attack which has not resulted in the diagnoses of anxiety, it's likely to fail. So the mens rea, Savage Parmenter, states that there is no separate mens rea. The mens rea is identical to the underlying common assault and nothing more. So if you have a battery as your underlying act, prove the mens rea for battery, so you use R.V. Venner. If you have assault, use Savage. So Section 20/18 GBH/wounding. We'll start first with wounding. So D might be charged with wounding contrary to the Offences Against a Person Act 1861. So this is governed mainly by JCC v Eisenhower and defined. So a wound requires for the injury to result in a break in the continuity of the skin. So this means both layers of the skin, meaning that scratches, grazes, burns and broken bones do not class as wounds, although skin can also include the inner linings of the lip and cheek. Obviously, speaking biologically, the skin does not just have two layers. But for the case of the law, because this was drafted in 1861, they obviously did not have microscopes that were able to discern this. So it would be one layer and then the next layer, which would result in bleeding. So D could be charged with GBH, and according to the Offences Against the Person Act 1861, so Saunders defined GBH as requiring serious harm. Burstow warrants psychiatric harm provided that it is classed as serious. So likewise with ABH, where there is a clinical condition, likely anxiety, depression could be in there, but things like perhaps PTSD, events that trigger BPD, DID, these severely mentally debilitating disorders might be classed as grievous bodily harm. So case law shows that serious injury is demonstrated by injuries such as badly broken bones, injuries that require lengthy medical intervention, treatment, permanent disability, or disfigurement. So Bollum states that GBH is more serious against vulnerable victims, elderly, young, or disabled in people, for instance. So we'll come on to this afterwards, but if you're looking for a way to discern between section 20 and 18 GBH, you'll have to contextualize the case law as a whole, obviously, but generally speaking, if it's against the elderly or the young or the disabled or those who are vulnerable victims, you can look at section 18 more than section 20, provided that the rest of the case facts warrant that. So Brown v. Stratton states that individual injuries that would ordinarily class as ABH can accumulate to form GBH. Biological GBH is mentioned with the case of Dika and Mabanda with HIV and Golding with herpes. So now that we've established the legal capacity for both, we must determine between section 18 and section 20. So keep in mind Bollum. But section 18 is a specific intent requiring direct and oblique intention. So this is governed by R.V. Mohan and Woolin. So section 20 is a basic intent, however, which requires direct intention and recklessness, which we've gone on before. Section 20 requires 5 years in prison, maximum. Section 18 has a maximum sentence of life imprisonment. So for it to be section 20, they must only foresee some harm, which is governed by R.V. Mohan. So the phrase foresee some harm needs to be memorized. That is absolutely key. So section 18 the defendant must intend serious harm. So that's why it is specific intent requiring just pure intention and not recklessness, because of the definition given in Nedrick, which is intend serious harm. So the clues for this could be the use of a weapon, attacks at the head, premeditation, gang attacks, injury of a police officer whilst resisting arrest. So murder is defined by Lord Coke as the unlawful killing of a reasonable person and being under the King's peace with malice aforethought express or implied, and is governed under the Offences Against a Person Act 1861. This can be an act, but can also be an omission where there is a duty to act. So this is governed by duty by a relationship, so that's Proctor and R.V. Dytham. Contract, which is Pitwood. I believe Dytham is contract, actually. Voluntary assumption of care with Stone and Dobinson, duty to minimise with R.V. Miller 1983, and a duty arising from statute, so for example the Road Traffic Act. So the first element is an unlawful killing, so this satisfies as long as it is anything that is not state sanctioned execution or self-defence, for instance. So for somebody to be a reasonable person and being is defined by the Attorney General reference number 3 of 1994, which defines a reasonable person and being as an individual who is fully expelled from the womb and capable of independent breath. So technically speaking, a baby that's half born and then gets murdered is technically not a reasonable person and being, because they are not capable of independent breath, because they are still using the umbilical cord, and they have not been fully expelled from the womb. However, how the courts will deal with this, I'm not entirely sure. This means that those on life support are not legally classed as a reasonable person and being. So that's Malcherek, and a child still in the mother's uterus is not a reasonable person and being either. So now you do causation again. Also, remember for the Novus Actus Interveniens, I didn't include this in the last one, I'll amend that. But remember R.V. Blau, which is thin school rule, so you just take the victim as you find them. So it does not matter that R.V. Blau had a thin skull, essentially. So, under the King's Peace, you must establish whether this is at war or during a time of civil unrest. If not, then you're fine. So, next is the mens rea, which is governed by the phrase malice aforethought, express or implied. This is just direct or oblique intention. So, R.V. Vickers describes the mens rea for murder as the intent to kill or cause GBH. This is because if you intend to kill but you only cause GBH, and there's no proof that you intended to kill, then you could maybe get away with Section 18 GBH, or even less, Section 20. Obviously, if you look at the two offences, you would rather get convicted with Section 18 GBH than murder, because while they are decently close in severity, you're more likely to get a harsher sentence with murder than you are GBH, naturally, due to the difference in severity of the crimes. So, direct intention, Miriam, was it D's intention? Was it the purpose of D's act to kill V? Was it the purpose of D's act to inflict serious bodily harm onto V? So, then oblique intention with Woolen: was death an inevitable side effect and thus a virtual certainty of the defendant's acts, and did they appreciate this? So, you must memorize both phrases. So, fatal offences: gross negligence manslaughter. This is a basic intent crime as well. This is not specific intent. So, when I was studying law, the emphasis was put on GNM. It's kind of like a hybrid case between tort law and criminal law. And this is because of the phrase negligence. So, the principle of duty of care is a tortious concept. So it's weird that it's kind of being combined into the two. So the elements come from the case of Adameko. D must owe V a duty of care and must have breached that duty, which then had a risk of death, and the negligence must have been serious enough to be considered criminal. So the first element is a duty of care. So this is governed by Donoghue v. Stevenson, Lord Atkinson's neighbour principle, which stated that a duty is owed to any persons who is so directly and closely affected by my acts or omissions that I ought reasonably to have them in my contemplation. This is for the judge to decide. So in Evans, a duty of care is demonstrated in Stone and Dobinson as a voluntary assumption of care. A contractual duty is demonstrated in Singh, and Wacker shows that while criminal complicity usually negates the reliance of a civil duty of care, it won't prevent such a duty if it results in criminal liability. The second element is establishing a breach in care. For this, the defendant must have fallen below the standards of an ordinary reasonable man. The case of Edwards shows that a breach will occur when D ignores an obvious and serious risk. The breach of duty must carry a risk of death. Mizra Shrivastava confirmed it must be the risk of death and not bodily injury or the defendant compromising of health. So it cannot be a simple complication that is calculated to interfere with the health or comfort of the victim. It has to be death. So finally, the negligence must have been enough to classify it as criminal. The Bateman test is used. So this asks, has D shown such a disregard for the life and safety of others to warrant a crime against the state? There's meant to be a quotation mark there. The case of Andrews states that a simple lack of care which would constitute a civil liability is not enough, but it must be a very high degree of negligence. This is because if it is able to be satisfied and if it is able to be dealt with in a civil court, then that's better than a criminal court. Because even though they are negligent, and you might say, why are they getting sympathy from the state? Ultimately, if it is not high enough to be recognized as a criminal act, then it shouldn't be recognized as such. So you must show the mens rea for the crime committed, so intention or recklessness as to creating a dangerous situation. So you ask yourself, did the owner willingly let it happen? So you ask yourself, did the owner willingly let it happen, and did they do nothing to resolve it? So it's the did they do nothing to resolve it despite knowing that causes it to be serious. Next on fatal offences is unlawful act of manslaughter. So unlawful act of manslaughter must be comprised of an unlawful act that is considered dangerous and causes death. The defendant must also satisfy the mens rea for the unlawful act. So like ABH, there's an underlying act for this as well. The first element tells us that the act must be unlawful. Lam tells us that a criminal act must be proven. Low tells us, however, that an omission is not enough. So in this case, give the AR for the unlawful act if it is part of the spec. If not, give a reasonable definition, something like rape or like poisoning someone. I'd say like administering noxious substances, or the unlawful unconsented penetrate, or something like that. Do you know what I'm trying to say? So yeah, do something like that. So the act must be proven to be dangerous. The defendant must not foresee serious harm, but of some harm. So this is in church. This test is objective. The defendant need not have foreseen some harm, but a sober and reasonable person would have. This means that it is not based on the subjective interpretation of events relative to the defendant's perspective, but of the average sober individual. This confirmed in RVJF. So essentially, it's not from, if you use the principle in self-defense that is from the defendant's point of view, with this one, it's reversed. And that's what makes it objective, because it's not from the defendant's point of view, but from the average person, or what the concept of an average person would be. So Mitchell tells us that battery is considered dangerous. Dawson tells us that fear alone does not satisfy the criterion of danger, unless a reasonable person would foresee such based on the visibly vulnerable and frail appearance of the victim. So Watson. Goodfellow tells us that harm can be aimed at property. Next, we must prove that the act was the cause of death. Corian Auguste tells us that the normal rules of causation apply. The unlawful act need not be the sole cause of death so long as it is not trivial. So that's Shohid. Attorney General reference number 4 of 1980 states that if a series of unlawful acts leads to the victim's death, it is sufficient to say that any one of those actions could have caused that death. Kennedy states that the victim's own act can break the chain of causation. So Carey states that a single punch was not considered dangerous enough to be considered the cause of death, but contextualize this though and say why. So it's not essentially saying that a single punch is not dangerous, but in the event that they had, so in Carey's case, she had a medical disorder. They had a cardiac medical disorder, which is essentially a disease of the heart that was described as a ticking time bomb. So this essentially states and it implies that even if the punch wasn't administered, there was a chance that she would have died anyway because of the condition. It was not the punch as per se, but it is a controversial judgment that was made. So next are the partial defenses to murder, being loss of control. So D may be able to argue that the partial defense of loss of control is valid in their prosecution for murder. This is governed by section 54 to 55 of the Coroner's Justice Act 2009. We must prove that, stated in section 54 subsection 1, that D lost self-control brought on by a qualifying trigger, leading him to act in the same way that a reasonable person of the same age and sex would have. Section 42 subsection 2 of this Coroner's Justice Act 2009 states that the loss of control need not be sudden. However, the longer the delay, the harder it is to prove, so that's shown in Ibrams and Gregory, or Ibrams and Gregory. Contrary to previous legislation, however, this allows for the slow burn effect to take place, shown in Alawalia and Thornton, which was previously denied according to the Homicide Act 1957. Jewell states that it must be a snap. He must have really quote-unquote lost it. Any evidence of premeditation or planning immediately invalidates the defense, which is governed by section 54 subsection 4. So Next, you must prove that D snapped as a result of two qualifying triggers. Section 55, subsection 3 tells us that a genuine fear of serious physical violence against themselves or an identifiable person can suffice. Section 55, subsection 4 states that something said or done which is so grave that it brings the defendant a justifiable sense of being wronged also qualifies as a trigger. So Zebedee and Boyer states that the word things must be seriously grave. Sexual infidelity is immaterial, as said by section 55, subsection 6, subsection C. However, it can be a contributory factor. So remember in your law essays that everything is within context, right? You follow the legislation, you contextualize it, and you reach a reasonable conclusion. That is why generally it's immaterial. However, it can be a contributory factor based on the facts of the case. So finally, the defendant is expected to show a normal degree of tolerance and self-control. This is an objective test, so section 54, subsection 3. Only sex and age can be considered from the defendant's perspective, but Gregson and Hill states that psychological illness and a history of sexual abuse, respectively, can be considered also. So the next partial defense to murder is diminished responsibility. So this is governed by section 52 of the Coroner's Justice Act, which defines the requirements for being in a diminished responsibility as having suffered from a recognized medical condition that causes an abnormality of mental functioning, which substantially impairs D's ability to understand the nature of his conduct, form a rational judgment, and or exercise self-control. This must also prove an explanation for the killing. Byrne defines abnormality of mental functioning as a state of mind so different from that of the ordinary human being that any reasonable person would deem it as abnormal. Ultimately, this is up to the jury, but can be speculated, and you will have to discuss this in your essays. So, recognized medical condition is wide enough to cover psychological and physical illnesses recognized by respected organizations such as WHO or the NHS. Depressive conditions is dealt with in Gittins. Alcoholism is dealt with in Wood. Battered wife syndrome in Alawali and Thornton. However, binge drinking is not permissible. However, look out for alcohol dependency syndrome, but binge drinking is not permissible. So that's shown in Dowds. Secondly, the abnormality must substantially impair the defendant's mental responsibility. So, seen in gold, substantial should be given its everyday normal meaning. The jury should use their common sense when reaching a verdict. It must substantially impair the defendant's ability to understand the nature of their conduct, form a rational judgment, and or exercise self-control. Any one or a combination of these impairments must be present. Finally, abnormality of mental functioning must provide an explanation for the killing. Alcohol dependency syndrome, for instance, there must be a causal connection established. I don't think you necessarily have to use the whole causation or RV White thing, but establish a strong enough connection that it can be causal and not correlational. If it is more on the correlational side, then your defense is weak. So consider Deichmann for intoxication or hints of alcohol dependency syndrome. Regardless of his intoxication, was his condition a significant contributory factor? So, now to property offences. Theft, we're halfway there. Section 8 of the Theft Act 1968 defines theft as any act that dishonestly appropriates property belonging to another with the intention of permanently depriving them of it. So the first element is appropriation. So Morris states that it is the appropriation of any one right of the owner. Lawrence, confirmed in Gomez, states that you can appropriate with the owner's consent if such is obtained dishonestly. Hinks states that you can appropriate gifts if they are obtained dishonestly. So it revolves around the concept of dishonesty. So the next element is property, governed by Section 4 of the Theft Act. This states that property includes money, personal property, things in action, and real property, provided that it meets the conditions of Section 4, subsection 2. This includes tangible property illegally possessed, seen in the case of Smith. Section 4, subsection 2 states that land cannot be stolen unless D is a trustee, representative, or has the power of an attorney or breach in trust. That D severs or causes part of the land to be severed and is not in possession of it. D is a tenant and appropriated the whole part of a fixture. So Oxford v Moss states that confidential information is not property. Section 4, subsection 3 states that wild plants and mushrooms, unless done so for reward or commercial purpose, and section 4, subsection 4, creatures, unless tamed or kept in captivity, are not property. It's like tongue twisters. So dead bodies, look for that in the case of Williams v Williams. There's Kelly and Lindsay as well, and exception for the rule is seen in Akbar. So the next element to prove/disprove theft is to discover whether it belonged to another, governed by Section 5 of the Theft Act 1968. This is the final element of the actus reus. For this, there must be a demonstration of the possession or control or degree or ownership or proprietary right over the property. Turner number 2 states that you can steal your own property. Section 5, subsection 3 states that property received under an obligation belongs to another. This is seen in the case of Davidge v Bennett. That is meant to have two ends. Section 5, subsection 4 also states that property received by mistake belongs to another. That's seen in the case of Shadrock Sigari. Williams v Phillips states that rubbish left for the bin men belongs to the council. Whether property is lost or abandoned is a matter of the jury. That's seen in Ricketts v Basildon, close bracket. Lost property is considered to belong to the person who lost it, Bridges v Hawksworth. However, the finder has a better claim to it unless it was in the ground, Waverley Borough Council versus Fletcher, or the finder was a trespasser, Hibbert v McKiernan. The first element of the mens rea as to theft is dishonesty. We must determine whether one of the three common law exceptions apply to the defendant. There is no definition of dishonesty. However, Section 2, subsection 1 provides guidance as to what might be considered dishonest. Section 2, subsection 1, subsection A states that D may not be dishonest if he genuinely believes he has the legal right to the property. Remember, obviously, we're in 2023. Try not to use he unless if the defendant is a male or identifies as a man, because technicality speaking and grammatically it should be they. It's just that the law is sexist, so in legislation they often say he. So Section 2, subsection 1, subsection B states that D may not be dishonest if there is genuine belief that he would have the owner's consent. Section 2, subsection 1, subsection C states that D may not be dishonest if he genuinely believes that the owner cannot be found by taking reasonable steps. In all cases, it is relative to D's belief, and it does not matter whether this was correct or reasonable, provided it was genuine. So that's seen in Holden. This is also tested via the Ghost test as amended in RVV Genting Casinos and confirmed in Barton and Booth. This asks, would the defendant's behaviour be regarded as dishonest by the standards of reasonable and honest people? This is an objective test and is not relative to the beliefs of D. Section 2, subsection 2 states that a person's appropriation of property belonging to another may not be dishonest, notwithstanding that he is willing to pay for the property. The final element of the mens rea is to determine whether D had the intention to permanently deprive V of his property. This is where D treats the property as his own to dispose of, regardless of the other's rights, seen in Lavender. Anything that is equivalent to an outright taking will be enough, as will borrowing or lending that has diminished the property in value, seen in DPP, VJ and others with broken headphones, and Lawyers v others. As a counteracting case, as there was no diminishing in value or goodness of the property. He stole film and returned it in perfect condition. RV Volumnal, however, he took money out of the safe, used it, put money back into the safe. However, it is not the exact same money, therefore it is permanent deprivation. Next property offence is robbery. Robbery is governed according to the Section 8 of the Theft Act 1968. It is essentially aggravated theft. So you must discuss the full offence of theft beforehand. This defines robbery as if he steals and at the time or before doing so he applies force or puts or seeks the fear of force into another person. If force is used the moment the theft is complete, then there is a robbery present. So that's Corrigan v. Anderton. Force does not equal violence, but it must be sufficient to be noticed, but not necessarily to the victim. That's Dawson and James. R.V. Clouden says that force can be applied to property. PVDPP says that with the use of force, it may be difficult to draw the line. To discuss the threat of force, we must apply the case of Bentham. This states that if it is D's intention to create fear, it does not matter that the threat was not real. If D's intention was to cause fear, then the victim's actual state of fear is immaterial. That's B and RVDPP. Timing can be difficult to establish, so you can implement the continuing act theory to use in your case scenarios for robbery. That's Hale, confirmed in Lockley. You must next prove that there is dishonesty with the intention to permanently deprive, plus the intention as to the application of threat or force. So establish the mens rea for theft and then state whether the defendant intended to use force or threaten force to perpetuate such theft. Obviously do so reasonably. So you shouldn't necessarily need to state every single part of the mens rea, but what applies to the case, or what you believe is reasonable relative to your essay. So Section 9 of the Theft Act governs burglary, and it defines it as if he A. enters any building or part of a building as a trespasser and with the intent to commit theft, grievous bodily harm or unlawful damage, or B. having entered a building or part of a building as a trespasser, he steals or attempts to steal anything in the building or part of it, or inflicts or attempts to inflict any person therein any grievous bodily harm. So these are the two categories and the two types of burglaries. So the actus reus of burglary, regardless of whether it is 1A or 1B, requires three elements. The first is entry, whose definition is developed from effective and substantial in Collins, through effective in Brown, leaning through a shop window to partial entry in R.V. Ryan. Next, the D must have entered a building or part of a building. There is no formal definition of this within the statute, but we know that it must be a fairly permanent structure, so not a tent, for instance. Section 9, subsection 4 states that building shall apply to also an inhabited vehicle or vessel. So this is true even if the person who inhabits the building is not there at the time. The case of Coleman confirms this to apply to houseboats, while Rodmell shows that it can be the same for outbuildings as well. So ignore the name, but next, so D must be a trespasser. If they have permission to enter, then he is not a trespasser but a visitor. The case of Walkington shows that it is only necessary to enter part of the building as a trespasser, while Jones and Smith states that a defendant may start out as a visitor. If he goes beyond the permission given to them to enter the property, then he will be a trespasser. So if somebody tells you not to go into the bathroom or not to go into their parents' room, and you go into their parents' room, as of that moment you are a trespasser. The mens rea of burglary requires two elements to be proven. So they must know or be subjectively reckless as to whether he is a trespasser or whether she is a trespasser. So then you test the direct intention as to trespassing / recklessness as to trespassing. So section 9 subsection 1 subsection A states that D must form this at the point of entry to commit theft, GBH or criminal damage. Section 9 subsection 1 subsection B states that D must form this, so the mens rea for theft or GBH, after they become a trespasser, and they must show the link to the actus reus that D commits or attempts to commit. So next is general defenses, so we're almost there. Speaking on technicalities, consent is not a defense but the denial of an existence of an offence as the victim allowed for such to occur. The doctrine of implied consent emphasizes that contact and force that are because of everyday situations, such as crowds of people, are permitted. So that's Collins v. Wilcox / Wilson v. Pringle. Certain situations where there is a mistaken belief to consent are also permitted, such as horseplay, so that's Jones. Attorney General Reference Number 6 of 1980 establishes a general rule as to consent to injury, stating that injury above those allowed from a battery is prohibited and would have to come under the recognized exceptions such as sport, medical or cosmetic procedures and sexual activity. So we must first establish whether the act is one that is viable to consent to. So first you identify the category of consent that the act applies to. So remember that if the injury is higher than ABH, then it automatically invalidates the defense. But consider sexual activity in sports. So with sports, injuries above ABH are allowed only if the act which causes injury is outside of the scope/rules of the sport, kind of potential for criminal liability to be considered. So that's bonds. Medical/cosmetic procedures. Consent is usually given by the patient in these situations, and consent is implied in life-saving circumstances. However, the patient reserves the right to refuse, such as a do not resuscitate form or RV Blau. So sexual activity. The law usually addresses extreme sexual activity, so Slingsby, Brown and others, and Wilson, and the deliberate transmission of diseases, that's Dyke and Mabanda. The consideration of genuine consent is crucial to this category, there being factors that may have detrimentally affected their ability to consent. This may refer to age, coercion, and if they are being tricked into giving their consent. So with regards to age, Borrow v. Harmer led to the development that age per se is not an automatic barrier to genuine consent. Failure to appreciate the nature of what they are consenting to is, however. The question is whether the victim has sufficient understanding and emotional intelligence to give consent in accordance with Gillett competence. But there is a consent through fear. This is not genuine, so that's Olugbojo. So ingenuine consent or not genuine consent is shown where a consent is obtained fraudulently if the fraud is to the nature of the act, shown into Bassam/Williams. So then identify the difference between D, tricking someone into the act by misrepresenting their identity or otherwise to perform the act, so Richardson. Self-defense is governed by the Criminal Justice and Immigration Act 2008 that states that a person may use such force as is reasonable in the circumstance in the prevention of crime. This is a full defense and results in acquittal. There are two elements that must be established and satisfied for this to function: the presence of evidence that the use of force was necessary and that such force was reasonable. Necessity of force more so refers to whether it is justified or not. This is judged on the circumstances the defendant believed them to be, which allows for a mistaken use of force to be allowed. So that's Gladstone v. Williams and Section 76, subsection 3 of the Criminal Justice and Immigration Act 2008. This is subject to the reasonableness of that belief being genuinely held, so Section 76, subsection 4. The allowance for preparations is allowed even if illegal in the Attorney General reference number 2 of 1983. Following preemptive strikes and are therefore justified, that's Bird, as D is not under a duty to retreat, so that's Section 76, subsection 6, subsection A, as amended by Section 148 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. Reasonable force is equivalent to proportionate force relative to the threat. Proportionality has been considered to not be able to be weighed to a nicety, the exact measure of a necessary action. So there is slight leeway in terms of slightly excessive force. So that's Section 76, subsection 7, subsection A. Despite this, though, a disproportionate amount of force does invalidate the defense seen in Hussein/Martin, but a further allowance of leeway is given to householders under Section 76, subsection 5, subsection A, where only grossly disproportionate force is enough to invalidate the defense. So this ruling does not give householders the discretion of using any amount of force they please, though, but only what is reasonable in the circumstances he believed them to be. So that's Collins v. SOS for Justice. Section 76, subsection 5 states that D cannot rely on mistaken belief if voluntarily intoxicated. So the next general defense is duress. Duress is the argument that they have been forced to commit the crime due to threats. However, this cannot be used as a defense to murder, how, or attempted murder, GOTS. To prove duress by threats, the two-stage Graham test with the 6 factors from Hassan must be used. We must decide whether D was compelled to act as they did because they feared death or serious physical injury, and this is not reliant on the severity of the crime. So you identify the threat. The threat must be directed against D, immediate family, or someone that D is responsible for. So that's Valderrama Vega approved in Hassan. The threat should relate directly to the crime committed, Cole. The threat should relate directly to the crimes committed, Cole, but the closeness of the connection between the two is not elaborated in case law. The second prerequisite for proving duress requires us to consider whether a sober person of reasonable firmness, sharing these characteristics, would have reacted in the same way. We must consider the characteristics identified in Bowen: age, gender, recognized mental disorder, serious physical disability, and pregnancy. Some characteristics are excluded, however, such as IQ, the disclosure of harmful or embarrassing information, and an unusually timid nature. There also needs to be no evasive action that could have been taken by the defendant, that there is no safe avenue of escape. The availability of police protection knows the defense. Jill Hudson-Taylor states that the fear of death or serious harm need not be immediate, but must be imminent and overbearing in the mind of the defendant. So Abdul Hussein. Evaluate the opportunity for D to report the threat and seek safety. How feasible is the safe avenue of escape? So consider whether the threat is self-induced as well. So that's Sharp/Shepherd. Duress by circumstance. This runs with the same mechanism as duress by threats, but rather than a person, it is the circumstance which defines them in that dictates the crime. So Martin. Necessity has similarities with duress of circumstance, Shayla, and seems to involve the requisite performance of the lesser of two evil acts. Necessity, as with duress, is not available to the charge of murder, Dudley and Stevens, although this has been called into question with Re A in 2000. The defense of necessity has also been used as a justification in civil cases in Re F in 1990. In contrast to duress, this defense can be used prospectively to justify controversial actions, especially medical procedures. So the first mental capacity defense is automatism. The result of such defense will lead to an acquittal, as it is a full defense like self-defense. The argument is that the act that D is prosecuted for was conducted involuntarily. Therefore, the essence of the argument is that the actus reus of the crime did not exist, alleviating liability from the defendant. Consequently, the defendant would not be responsible for their actions as it was involuntary. R.V. Bratty states that the standards for involuntary actions are extremely high, reinforced by Attorney General Reference Number 2 of 1992 that states that there must be a total destruction of voluntary control. This can be substantial or partial, so things like reflexes all the way to medical conditions such as epilepsy-induced seizures can qualify. Secondly, this must be caused by an external factor, so Hill v. Baxter for instance. However, ensure to be vigilant of any hint of self-infliction, as this will fail as seen in the case of Quick and Lippman through drugs. Mental illness such as PTSD are also seen as valid, so that's RVT. So that's next is intoxication. The success of the defense differs whether the crime is of basic or specific intent and voluntary versus involuntary intoxication. So first, identify the offence and the type of mens rea, narrowing the options. Voluntary intoxication with specific intent crimes states that there is sustained criminal liability if the mens rea of the crime was formed prior to intoxication. So that's NIV Gallagher. Despite this, if they cannot form the mens rea, then they are necessarily not guilty. DPPV Beard/RV Sheehan and more. However, he would be guilty of a basic intent crime. Voluntary intoxication with basic intent crimes. Maevsky states that voluntarily intoxicating yourself is innately a reckless course of conduct. Therefore, there is a satisfaction from the mens rea for the basic intent crime. Therefore, D is guilty where there is a voluntary intoxication with a basic intent crime. So involuntary intoxication in general, if the defendant is unable to form the mens rea while involuntarily intoxicated, they are not guilty. However, the formation of the mens rea, regardless of the involuntary nature of the intoxication, will reinstate their liabilities. That's Kingston. So in Kingston's case, he was involuntarily drugged, and in the process, he sexually interfered with a 15-year-old. As a result, he was prosecuted. This was his defense. However, they stated that he still knew what he was doing was wrong, as he confessed that if he was not intoxicated, then he wouldn't have done it anyway. In the ruling, they state that in order for this defense to be successful in that case, then Kingston would need to be totally legless. So, drunken mistake. If the mistake proves a negation of the mens rea, there is no liability. On the other hand, a mistaken belief for the need to defend oneself is not a defense. That's O'Grady confirmed in Hutton. Voluntary intoxication under a drunken mistake falls under the ruling in Majewski. So, insanity. The defense of insanity would result in the defendant being found not guilty by reason of insanity in accordance with SS 1 and 5 of the Criminal Procedures Insanity Act 1964. The defense must prove on a balance of probabilities that the three Norton rules are satisfied. So this is just a 51 to 49% chance essentially. These must prove that D was suffering from a defect of reason caused by a disease of the mind that results in D not knowing the nature and quality of the act or not knowing that the act is wrong. A defect of reason requires the defendant to be deprived of the power of reasoning, which is specifically the inability to use such reasoning rather than failing to use reasoning. Secondly, the defect of reason must be caused by a disease of the mind. A functional disease of the mind refers to affecting brain function, such as schizophrenia, paranoia, or bipolar disorder. An organic disease of the mind, however, refers to a physical condition that affects how the brain works, such as epilepsy in Sullivan, arteriosclerosis in Kemp, brain tumors, sleepwalking in Burgess, and diabetes Hennessy. Voluntary intoxication prevents this, however, in Coley. A defect of reasoning caused by the disease of the mind must result in D not knowing the nature and quality of the act or not knowing that such an act is wrong. The defendant being conscious but not knowing what they are doing in Oye, or knowing what they are doing but not knowing that it is legally wrong in Windle counts as well. So, moving on to preliminary offences and attempts. Attempts are governed by the 1981 Attempts Act. Section 1 of the Attempts Act states that if, with the intent to commit an offence to which this section applies, a person does an act which is more than merely preparatory to the commission of the offence, he is guilty of attempting to commit the crime. The actus reus of the offence is that a person does an act that is more than preparatory to the offence as decided by the courts. They held that this, instead of the AR of the crime, is needed. Gulliver states that merely preparatory is defined as the surpassing of preparatory actions. They must have embarked on the crime proper. The case of Geddes had the charged crime of attempted false imprisonment quashed as there was premeditation. However, he had not attempted to contact the students of the school. The courts of appeal considered asking the two questions. Had the defendant moved from mere planning and preparation to execution or implementation? Second, had the accused done an act showing that he was trying to commit the full offence rather than getting ready or putting himself in a position or equipping himself to do so? R.V. Campbell states that a defendant outside of a post office with an imitation gun, wearing sunglasses, and had a threatening note in his pocket. Despite being convicted for attempted robbery, this was later quashed on appeal. This demonstrates that moving from merely preparatory to embarking on the crime proper goes beyond even standing outside of a post office, but would arguably have been if he entered the post office and or used a note or threatened the cashiers, etc. In Boyle and Boyle, the defendant was found standing next to a door with the door hinge and Boyle and Boyle finds that the defendant was found standing next to a door, the hinge and lock broken. Their conviction for attempted burglary was upheld, however, as they attempted to gain entry. We have Toasty and White, we have R.V. White as well. So speaking on impossible crimes to commit, the attempt is merely the act of the defendant in a relation with the intent to kill/commit the full offence. Therefore, the possibility or impossibility of the success of the crime is irrelevant. The attempt was to kill his mother, which translates to more than mere preparation. In the mens rea, D must be proven to satisfy the correct mens rea for the attempt crimes. The courts require the same mens rea as would be required for the full offence, except for attempted murder, which requires the intention to kill only and not GBH. So that's why, bro. If intention to commit the full ordinary offence cannot be found, then the attempt will fail at ESOM, plus Millen and Vernon. Culpability cannot be proven with recklessness. However, Attorney General Reference Number 1 of 1992, The defendant forced to go into a shed with the intent of raping her. He was found with lowered trousers and interfered with the girl, however, did not succeed in penetration. The charge of attempted rape was upheld, however. The defendant need not have performed the last act before the crime proper, nor need he have reached the point of no return. Attorney General reference number 1 and number 2 of 1979, the courts determined that if the defendant had a conditional intent, for instance, would only steal if there was something worth stealing, he would still be convicted of the attempted offence. So then apply the test of Moen. So concepts of impossibility again, section 1 subsection 2 of the Criminal Attempts Act 1981. A person may be guilty of attempting to commit an offence even though the facts are such that the commission of the offence is impossible. Anderton v. Ryan attempted to buy stolen goods that weren't stolen. The courts found him not guilty, however, it was impossible to commit the crime. However, this was overturned by Shuvpuri, attempted to receive a suitcase of drugs but only contained vegetable peelings, and she was convicted.